How can you not condemn a statement calling Justice Clarence Thomas a house slave? Come on, folks. That's all this amendment does. I mean, does anybody here support that kind of rhetoric? I don't. I don't think you do. And this kind of rhetoric hasn't been directed toward John Roberts. It hasn't been directed. Mr. Chairman, I would call up Amendment SIL 23885, SIL 23885. This amendment would simply condemn the racist things that have been said about Justice Clarence Thomas.
Anyone seek recognition on this amendment? Senator Kennedy, is it safe to say that you condemn all racist comments and attacks on all justices?
Sure, particularly Justice Clarence Thomas. I think he has been the target of most.
You would not include the other African-American justices in the court?
Includes everybody in the world, but particularly Justice Clarence Thomas, because I think we all know he's been the target of most of them.
If the senator would agree to put that into the amendment, I think we could accept it.
I'm happy with my amendment.
You happy to change it, you say?
I'm happy with my amendment.
So to be clear, Senator Durbin, you're talking about simply saying that we condemn racism against any justice, but
That's
that
all.
he will only put one justice in?
That's right.
I don't understand the reluctance to accept the fact that Justice Clarence Thomas, who happens to be a black man, has been the butt of a lot of racist statements. And I don't understand the reluctance to condemn those. And that's what my amendment does. I don't want to water it down. I don't want to bubble wrap it. I don't want to sugarcoat it. I want it to say, big as Dallas, the United States Senate condemns all these racist things that have been said about Justice Clarence Thomas. Now, if somebody wants to offer another amendment to condemn every racist thing that has ever been said in the history of ever, I will vote for it. But this one is about Clarence Thomas. And I'll support going through justice by justice, all of whom have, anybody who's ever served on the Supreme Court. But this one, and I think we all ought to go on record, is about Clarence Thomas.
Will Senator Kennedy yield for a question?
Yes, sir.
I'm reading your amendment, which I think is very well drafted. One of the things you cite is on July 13th, just a few days ago, 2023, Minnesota Attorney General Keith Ellison disgustingly likened Justice Thomas to a house slave from the film Django Unchained. Are there any of the other 9 justices who have been subject to such racist attack in the last few days from a sitting Democrat in the state of Minnesota? Has anyone else been subject to those kind of attacks as frequently, as brazenly, and as unapologetically?
No, sir. And it would be unconscionable for this committee not to condemn that kind of rhetoric for Clarence Thomas.
Mr. Chairman, despite Senator Graham's view of the breadth of this bill and the debate, I consider this to be not relevant to the matter at hand. And further, it specifically requests the Biden administration to inject itself politically into a law enforcement decision that the Biden administration, I think quite properly, has avoided getting involved with. So I urge my colleagues to vote no.
Any further discussion on this amendment? If not,
Are you going to offer a second degree then on the?
I have some discussion.
Senator Kennedy, your amendment.
How can you not condemn a statement calling Justice Clarence Thomas a house slave? Come on, folks. That's all this amendment does. I mean, does anybody here support that kind of rhetoric? I don't. I don't think you do. And this kind of rhetoric hasn't been directed toward John Roberts. It hasn't been directed toward Neil Gorsuch It's been directed toward Clarence Thomas. And it's un-American, it's unconscionable, and I can't believe we wouldn't condemn it. I don't care how many lawyers can dance on the head of a pen. Don't try to pretend that this is some sort of a technical mistake in this amendment. It's not complicated. You don't have to be a senior at Caltech to figure it out. It says all of this stuff about Clarence Thomas, calling him a house slave, and other racist, disgusting statements we condemn. Now, you either condemn it or you don't. And that's all this amendment does.
If I may respond, I, for one, do condemn that sort of rhetoric, but the senator's amendment does more than that. It calls upon the Biden administration to enforce Section 1507 of Title 18 United States Code to protect Supreme Court justices, including Justice Thomas, in light of flagrant violations of the law designed to intimidate justices. We've had a lot of time in this committee trying to make sure that the White House and the political side of the executive branch is kept out of internal Department of Justice law enforcement decisions. And in the light of that, I again ask my colleagues to vote no unless there's a second-degree amendment that clears that problem.
Mr. Chairman.
I respect my colleague, Senator Whitehouse, and he's better at me counting the number of lawyers that can dance on the head of a pen. But this is a real simple amendment. If you support the racist things that have been said about Clarence Thomas, then vote against this amendment. If you think the things that have been said about Clarence Thomas are racist to the marrow and you condemn them, then vote for this amendment.
Someone else seek recognition. Senator Lee.
I support this amendment wholeheartedly, and I find it difficult to understand, number one, how someone could oppose an amendment whose sole purpose is to condemn racist slurs used repeatedly, publicly, and viciously against one Supreme Court justice. Now, yes, other things have been said about other justices. That's true. Other things have been said about other justices on both sides of the aisle. Justice Thomas is unique on the court in that, to my knowledge, he's the only current member of the court who's been attacked racially, even in supposedly polite society. Attacked by television news personalities using those same racist terms. So I find it difficult to understand why anyone would object to sending that message. Now, as to the second objection, I also find it very difficult to understand why someone would oppose this.
Don't do that.
We've already established nothing objectionable about wanting to weigh in and say those things shouldn't happen. They should be retracted and they should never occur again. But now we hear an objection based on the additional fact that this amendment calls on the Biden administration to enforce 18 U.S.C. Section 1507. These same verbal attacks invariably culminate in and lead to and encourage and foment through groups like Jane's Revenge the kinds of activities outside of justices' homes that leave them in a physically vulnerable position with their personal safety and security being threatened and violated. There's nothing about this that says exactly what enforcement action has to take place at exactly what location, in what moment. There's nothing in this that doesn't take away a degree of discretion on the part of law enforcement officers. But the truth is, this is not being enforced at the homes of the justices. It isn't. And we know that it's not. We know that decision is deliberate because of the leaked internal memoranda obtained by our colleague, Senator Katie Britt from Alabama, who received them, I believe, from a whistleblower. So we know that they're being instructed not to enforce this at the homes of the justices. I find it almost impossible to understand how someone would object to this amendment, either on that basis or any other.
Senator Cruz.
Mr. Chairman, two arguments have been proffered against Senator Kennedy's amendment. The first argument is, well, gosh, maybe there have been racist things said against other justices. I will point out objectively the venom and bigotry directed at Clarence Thomas is qualitatively different from any of the other 8 justices. This resolution gives multiple instances of elected Democrats currently in office launching racial epithets with complete impunity. It cites how Representative Benny Thompson of Mississippi, a Democrat member of Congress, called Justice Thomas a, quote, Uncle Tom. It cites how just a week ago, The current sitting Minnesota Attorney General, another Democrat, Keith Ellison, disgustingly likened Justice Thomas to a house slave, and a house slave from the film Django Unchained, a particularly vicious and loathsome character from that movie. If the chairman wishes to point to instances of any elected officials using racial epithets towards any of the other 8 justices, I will happily condemn them. I'm not aware of any. Might there be some lunatic on Twitter who said something? Sure, there are idiots out on Twitter. But these are not fringe characters. This is a senior Democrat in the House of Representatives who refuses to apologize. And this is the current Attorney General in the state of Minnesota. And so everyone should understand, look, I expect a party line vote on this. I expect all the Democrats to say no. But understand, everyone watching this will interpret that quite rightly to say, you agree these kinds of racial insults at Justice Thomas are perfectly acceptable. Justice Kennedy said he assumed that Democrats denounce these statements. I have to say, I haven't heard any members of this committee denounce what Keith Ellison said. I haven't heard anyone call on Keith Ellison to retract and apologize. The Democrat Attorney General in Minnesota, I haven't heard a word about that. The second argument given was the argument given by Senator Whitehouse, and he says, well, the part that is offensive of this is it calls on the Department of Justice to enforce the law. Just stop and repeat that to yourself again. So it is now the position of Democrats that it is unacceptable to ask the Department of Justice to enforce the law. It is an existing criminal statute, section 1507, that makes it a federal crime to protest at the home of a justice with the purpose of intimidating them. This Department of Justice refuses to enforce that law. And I will say, with the argument being made by Democrats right now, it reveals the whole game. The reason the Biden Justice Department ignores federal law and won't actually prosecute the criminals who are trying to intimidate and threaten Supreme Court justices is because the Biden administration supports that criminal threatening. And the reason now that Judiciary Committee Democrats are being told vote no on Senator Kennedy's bill is because Senate Democrats on the Judiciary Committee support that violent threatening of justices. This bill is not about ethics. It's about a double standard applied to justices with whom Democrats disagree. It is designed to delegitimize the court. It is applying rules that are not applied to liberal justices like Stephen Breyer and Ruth Bader Ginsburg and Sonia Sotomayor, who have committed conduct virtually identical to that of Justice Thomas and others. But the Democrats on this committee are mad at the Supreme Court because it's issued decisions faithful to the Constitution that are inconvenient for the political agenda of Democrats. Look, we're defined by the votes we make here. If every Democrat happily votes no, understand you're telling your constituents you think it's perfectly fine to call a Supreme Court justice a house slave, and you can't muster up the courage to say that's beyond the line.
Senator Cruz, would you yield to a question?
Happily.
Would you read one more time, for the record, that statement about Justice Thomas and who made it?
On July 13th, 2023, Minnesota Attorney General Keith Ellison, the currently sitting Attorney General, offensively likened Justice Thomas to a house slave from the film Django Unchained. And by the way, there's a long pattern of that. On April 27, 2014, Democrat Representative Benny Thompson of Mississippi, again another sitting Democrat member of Congress, used racially charged language to characterize Justice Thomas, including calling him an Uncle Tom. I'll point out also recently, on February 14, 2023, Georgia State Senator Emmanuel Jones used similar racially charged language to characterize Justice Thomas, including by calling him an Uncle Tom figure. The choice Democrats have to make. Do you think it's all right to call a justice who dares disagree with you an Uncle Tom? I think it's bigoted. But perhaps Democrats hold themselves to a different standard.
Let me respond. We condemn racist attacks of any kind from any source, elected or unelected. We have had current members of the United States Senate who've had to apologize publicly for the statements they have made involving the issue of race. We should not compromise on that integrity of that principle, regardless of whether the victim is a Democrat or a Republican, a Supreme Court justice or not. So I'm going to propose an amendment to this Kennedy amendment, which I think will encapsulate our position on this side. And if you want to go to page 3 of the amendment and follow along, it's pretty simple. On page 3, line 13, to insert after the word against, any current or former Supreme Court justice, including, and then it preserves the rest of the language you have in that line, Senator Kennedy. And to strike on page 4, paragraph 5 in its entirety. I would offer that as an amendment in an effort to bring this to a bipartisan conclusion, and it is now the pending amendment before the committee. Any comment, question?
Mr. Chairman, can I ask, so
Go ahead, Senator
as
Coleman.
the second degree amendment, you would strike the name of Clarence Thomas?
No. Include every word on pages 1 through 3 of the amendment. I've just inserted additional language to say any current or former Supreme Court justice, including. So there's no other change.
Would the chairman consider making those amendments separately? Because the First Amendment you suggested, I'd be willing to vote in favor of. The Second Amendment, striking the paragraph calling on the Department of Justice to actually enforce current and existing federal criminal law, I could not vote for. But if you broke them up separately, I'd be happy to vote for the first one.
I have no objection to that. I think that that's a reasonable request procedurally. Are there any other comments or questions? If not, then the first second degree amendment will be as follows. On page 3, line 13, to insert after the word against, quote, any current or former Supreme Court justice, including, go on to the rest of the amendment.
Will the chairman yield for
Happy
question?
to yield, Senator
Does
Kennedy.
it mention Justice Thomas by name?
Your amendment does completely.
Yep, but does your amendment, does it take out
says-
the reference specifically to Justice Thomas?
It says including Justice Thomas,
Okay, that answers my
including
question.
those likening him. So I
Thank you.
don't delete any words from your original amendment related to Justice Thomas. Can we do this by voice vote? It sounds like the First Amendment may be agreeable. Yes or no? Senator Kennedy? Okay. All those in favor of the Durbin second degree amendment as described to the committee, say aye.
Aye.
Opposed, no. Depending on the chair, the ayes have it. So the second degree amendment, the amendment is agreed to. The amendment's agreed to. The second degree amendment strikes on page 4 all of section 5. I know that is not one that we're going to get bipartisan agreement on, so I suggest the clerk call the roll.
It began as a procedural request and turned into a moral crossroads. Senator John Kennedy called up Amendment SIL 23885, a simple line on paper, he said, with a singular purpose, to condemn the racist things said about Justice Clarence Thomas. No labyrinthine caveats, no soft edges. I don't want to bubble wrap it, he told the room. I want to say, plain as Dallas, that the United States Senate rejects the language that called a sitting Supreme Court justice a house slave. The air tightened. This was not theory. This was not a hypothetical. It was a demand that the Senate say what it means when it says it opposes racism. From the dais, a quiet probe. Could the condemnation include all justices, all races, all slurs, all victims? A universal principle is easy to defend. Kennedy did not flinch. This amendment, he said, is about Clarence Thomas, about a black man on the nation's highest court targeted with dehumanizing epithets by public officials and media figures who should know better. He did not forbid a broader resolution. He welcomed it. I will vote for it, he promised. But he would not dilute this one. He would not widen the lens to avoid the hard truth in the frame. This, he said, is where we go on record. The scene crystallized when Senators Mike Lee and Ted Cruz pressed the particulars into the transcript, chiseling dates and names so the moment could not slide into abstraction. Minnesota Attorney General Keith Ellison, July 13, 2023, likening Thomas to a house slave from a film. Representative Benny Thompson, 2014, wielding Uncle Tom as a political cudgel. Georgia State Senator Emanuel Jones, echoing that same slur in 2023. Here were citations. Here were receipts. This was not the fog of social media or the anonymous contempt of a comment thread. These were officials. It is one thing to condemn racism in general. It is another to condemn racism when it is committed by your own allies, in your own time, against the man you find hardest to defend. Then came the fault line. Senator Whitehouse argued that the amendment, as drafted, did more than condemn speech. It asked the executive branch to step in to enforce 18 U.S.C. 1507, the statute that governs protests aimed at intimidating judges at their homes. In this era of weaponized institutions, he warned, it is dangerous for the White House to lean into Department of Justice decisions. The point was procedural, but the implication was political. The tool you wield today could be used against you tomorrow. He urged a no vote. Kennedy did not budge. He called the objections what he believed they were, evasions. Don't pretend this is technical, he said. It's not complicated. Either condemn the racist attacks on Clarence Thomas, or don't. Vote yes or vote no. There, in that stark binary, the American dilemma took shape. We say we hate racism, we say we believe in equal protection, but when the target is unpopular and the vote carries a political cost, do we walk the talk or retreat to process? Chairman Durbin broke the stalemate with an old Senate craft, the second-degree amendment. He offered to add universal language to the condemnation against any current or former Supreme Court justice, including preserving Thomas by name, and to strike the enforcement section as a separate matter, a compromise with a boundary. The room shifted. The first change passed by voice vote, a rare, visible stitch of bipartisan fabric in a moment fraying by the minute. The second change, removing the call for DOJ enforcement, would go to roll call. In that division, one part consensus, one part trench line, the path of modern governance appeared. We can agree on the moral arch, but we quarrel over the levers of force. What does this tell us about power, leadership, and the American system? It tells us that moral clarity often collides with institutional caution. Kennedy's amendment was a test of moral reflex. Will you say out loud that this is wrong? Specifically, concretely, with names? Durbin's counter was a test of institutional prudence. Will you safeguard the structural distance between politics and prosecution, even when you see a wrong that cries out for action? Between them, Lee and Cruz insisted on the record that facts matter, that language wounds, that precedents of silence can metastasize into permission. The broader truth is harder. We have constructed a politics where condemning bigotry is easy only in the abstract, where universals are safer than particulars, where reputations bend under party wins, and where a vote to defend an opponent's dignity can be mistaken for a vote to endorse their jurisprudence. But if the court is more than 9 votes, if it is a civic altar of legitimacy, then defending one justice's humanity is not a concession. It is an investment in the only thing holding this experiment together, the belief that equal dignity precedes and survives our fiercest disagreements. The hearing ended on the cusp of that belief. A voice vote to say the right thing, an impending roll call to decide how far the law should reach. But beneath the procedure flowed a current older than our statutes, the necessity to name evil when it appears, to say, as a united Senate, that calling a black justice a house slave is not politics, it is degradation, and that an America that cannot draw that line with firm ink will erase more than a man. It will erase its own claim to moral leadership. This is the moment to choose courage over convenience, to prove that principle is not a costume we wear only when it flatters us, to show that the Senate can still speak in sentences that mean something, and that the court can still be protected by more than fences and marshals, protected by a people who refuse to dehumanize their opponents. Because if we normalize the language of hate against those who decide our law, we will teach a generation that victory requires humiliation and that justice has no guardians worth respecting. Here is the charge, plain as the gavel: condemn what must be condemned, protect what must be protected, and do it with names, not euphemisms. You're watching Congress Signal. If this work matters to you, if you believe sunlight and courage are the antidotes to cynicism, subscribe to Congress Signal and support our mission to bring you the unvarnished truth.